Any mention?
Please, Your Lordship, may be allowed to mention an unlisted matter.
What's
This is that matter that was passed last Friday regarding Sadaship of Nongpo. So I've come for KHDC to challenge that order.
For impleading?
No, not for impleading. Impleading is another one. It's for setting aside that order.
A miscase?
Yes, sir.
Then you serve copy, you'll have on Monday.
I've already served a copy.
On Monday, serve copy. Yes, you ready for today?
Today I'm ready, Your Lordship.
Then
We'll take it.
Please, my Lord. My Lord, I beg to mention item number 32.
One second, I think this matter is listed today also. Isn't the list today?
Item 6, supplementary.
Then you bring it now.
Yes.
It's already filed.
It's already filed. It's there in the filing section.
You call for that item number 6, call it together, miscase. There'll be 2 miscases, that means.
Yes.
Yes.
I beg to mention item number 32, my Lord. I pray that this matter may be taken up after the vacation.
32. Jingsang Marak.
Yes, we have no objection about the adjournment. Only thing is this, my lord, there is a stay of this honourable court. And my lord, the proceeding cannot proceed, my lord, because my lord,
vacate the stay order and
not order need not be vacated, my lord. Only thing is this: the CEM can proceed with the appeal, my lord.
If I may, Lordship. What happened, Lordship? They are against a village court order was passed by the village court that was sent for execution by the CEM. And thereafter, Lordship, CEM has recalled that order. So they have come against that, saying that CEM has no power to recall once the matter is before the district council.
No, they'll have after vacations.
The appeal has been filed. So I only pray for one observation, Lordship, that the appeal may be proceeded.
Well, there's an interim order, my
Nothing
Lord.
to do with the appeal.
Where's Mr. Mumin?
He's out of...
Put him to disadvantage, poor fellow.
No, then is okay, my lord. No. Then let it come out of vacation, my lord.
Interim order may be continued, my Lord.
Okay, after vacation.
Orders.
May it please, Lordship.
Yes.
Lordship, I beg to mention item number 31, my Lord.
Number?
31.
Why this matter will adjourn all the time?
Lordship, today, my Lord,
Tactical adjournment?
the conducting council has some personal difficulties not for today.
Yeah, objection?
No.
No objection? Okay, after 3 weeks after vacation?
Highly obliged.
May it please, Your Lordship, I beg to mention item number 33.
You are?
For the petitioners.
Petitioner?
Yes.
Who's for the respondent?
I'm for the state respondent, Your Lordship.
Okay, after vacation.
Yes. Highly
I beg to mention item number 30, my Lord.
Tata, you're not properly attired.
My Lord.
What is the Lordship?
Yes.
My Lord, item number 24 and 25, my Lord. On behalf of learned AAG, my Lord. Mr. Shulai is indisposed, my Lord.
I'm appealing for the petitioner.
24 and 25 is connected matter, my Lord. I'm for the state respondents.
What to do then?
My Lord,
Some urgency is there? No?
no, my Lord.
I have no objection.
Okay. After vacation. Yeah, they also Dr. Mojika?
Yes.
You no
sir.
objection?
Mr. Chula is not
Yes.
Deeply obliged.
Hey, please, Your Lordship. Your Lordship, I beg to mention item number 26. Your Lordship, the conducting council is...
He's still indisposed.
He's still in...
26.
You have some objection?
No, Your Lordship. They are the petitioners.
After vacation. Your Lordship, a similar prayer for item number 27, Your Lordship.
Okay, yes.
No objection.
You have no objection?
No objection.
Yes.
Obliged, Your Lordship.
I beg to mention item number 30, my Lord. Praying if this matter can be taken up after vacation.
Where's Dr. Mojika?
No objection, Your Lordship.
That's after vacation.
Much, Lordship.
Lordship, I beg to mention item 28. Mr. Chanda is not available.
Mr.
Chanda, Lordship.
Item number?
28.
After vacations.
Much, Lordship.
When you know, I mean, it's a stagger ki diya tha. I am jitni tha 1 week. I want to stagger no ki. Oh, that's no. Yes. Yes, that's it.
Supplementary list item number 1.
Yes, Mr. Khan.
May please, Your Lordship. Lordship, I filed this petition in a very, very limited ground. I filed a title suit before the trial court for declaration and possession of my suit land. In a missed case, after the defendant had filed a written statement, Lordship, the trial court had heard the matter at length, and after hearing the matter at length and appreciating the pleadings of both the parties, had passed a status quo order.
Okay, status quo order.
Status quo order.
As to the possession or what?
As to the possession and including the subject matter of the suit.
It's a suit for declaration.
Lordship, declaration and possession. Then the opposite party, Lordship, filed an appeal. An appellate court, after hearing only on a very, very small, limited using of the word dark number. Dark number instead of, we admit, Your Lordship, before the trial court also, and even with this, one of the ground that maybe in the pleading, the dark number should have been spelled out in detail. Instead of spelling out the detail, we quoted only one number. So that number does not it does not resonate with the actual patta in number. Based on that, only the appellate court has...
it's not the same number as the, for we seeking declaration.
Lordship, yes. But only one number, Lordship, but the patta number, the area and the boundaries are same. That has been elaborately discussed by the trial court. Lordship, I'll just come to page 107, para 12. Para 12 of page 107.
Para 12, yes.
In view of the above, it is observed that the perusal of the copies of different sale deeds that were executed on different dates between petitioner and opposite party, number 1, and his late brother Nur Hussain, as well as the copy of patta number. This is important, Lordship. Patta number 514 of the suit property that was issued on the basis of sale deed of the entire suit property and the Jamabandi that was issued by GHDC. It is enough for the court at this stage to prima facie presume that the petitioner is entitled to the suit property. It is pertinent to mention that the question of validity of the sale agreements and other merits of the case raised by opposite parties cannot be determined at this stage, and the same must be subject to evidence. Now, Lordship, I come to para 16, Your Lordship, the next page, 108.
Yeah. How can he hold it entitled to suit property in the 39 application? It's come to a finding. Title of prima facie case.
Prima facie case for only for
the vested right.
Vested right, only for the purpose of that. Lordship.
Furthermore, he is entitled to suit property. That finding is quite dangerous.
That is no doubt about it, Lordship. Yes. Trial course, yes, but only for the purpose of vested right. I'm grateful, Lordship. At least that has been clarified. Para 16, page 108.
Yes.
Furthermore, since it is seen that the petitioner is entitled to the suit property and that he has been in continuous occupation and possession of the suit property from the year 1992 and is continuously cultivating the suit property since 1992 without any dispute with the opposite parties, and the OPs are now disturbing the continuous occupation and possession of suit property by the petitioner, will no doubt be more of a burden to the petitioner than it will be to the opposite parties. Therefore, in view of this, it is observed that the balance of convenience therefore lies in favor of petitioner. Similarly, based on the above, given the petitioner has been in continuous occupation and possession.
Now his possession is undisputed.
Lordship, yes.
Yes.
And so, Lordship, this is para 12 and 16 are very clear on that. Now, Lordship, I'll just come to appellate court's observation, Lordship. Page 134.
134.
134.
Yes.
Para 31, Lordship.
Yeah.
Thus, it is seen that learned trial court has not taken into account the relevant facts and has not given finding as per the settled principle of law while considering the grant of injunction. The respondent plaintiff has alleged about so-and-so lessa being covered by patta number 514, dark number 740.
Yes.
And alleged schedule is not supported by any documents. Now, in the plaint, there is any whisper or statement as to how and in what manner the respondent became the legal owner of the plane covered by land covered by patta number 514, dark number 740 as mentioned in the schedule of the plaint. This is relevant, Your Lordship. The Annexure 8 to the plain land patta 514 does not contain any land under dark number 740. But the dark number is 936, 848, 102 and 739. The position of the plaintiff respondent is also in question. Thus, the respondent plaintiff has failed to establish prima facie case. Order of status quo cannot be granted when the prima facie case has not been established. The trial court finds the learned trial court has exercised its jurisdiction discretion arbitrarily, capriciously and perversely and ignored the settled principle of law regarding grant and refusal.
How can you say arbitrarily, capriciously and perversely?
Lordship, the only issue that the appellate court said what was in place of 936.
No, you see, the thing is that if this is in doubt, I mean the exact situation in the land, the appellate court was right in saying no one the plaintiff any whisper statements to how and what manner respondent became legal owner of suit land.
Lordship, there are supporting documents.
Number 740 is mentioned in the schedule of the plaint. The next number 8 of the plaint is land does not contain it, but that dark number 936, 848, now is it?
Lordship, we admit. Lordship, for the moment, I admit that it should not have been 7.
The same land is all.
Lordship, yes. Lordship, I'll just come to my to the plaint where I have stated this, Lordship. Lordship will come to page 21.
21 of
the petition application, para 2.
Yes.
This is, Lordship, we admit, it's an admitted fact that 740 should not have been there. The 3 other 4 numbers should have been there. We are not denying it.
That means that your plaint is defective.
Lordship, yes. I concede to Lordship, at least that is admitted fact, Lordship.
If that is the basis of the entire thing,
No,
then how will
Lordship,
you discern whether it's a correct land? Suppose now you give some other dark number and court gives some sort of status quo order injunction in you, and you go, the innocent third party, you take possession of the land and strengthen the orders of the court.
Lordship, allow me just to clarify this part. So for the patta number is concerned, 514, not disputed. So far the area is concerned, not disputed.
We issue notice now with order of status quo, but then
Lordship, yes. Lordship, yes.
Take
Lordship.
notice, but then do not
but Lordship,
change the nature or...
No, it doesn't. Only for status quo. Only for. And Lordship, one last submission, Lordship. In my pleading, I have made 740, which I admit it could have. It may appear to be wrong. It looks like wrong. But then Lordship is settled position of law that I am also next the copy of my Jama Bandi and the.
Whatever it is, that is not for this court to look into. Just to look into whether this order is sustainable or not. Yes, I heard Mr. K. Khan is a counsel assisted by Mr. Hassan for the petition. The counsel issue notice returnable in 4 weeks. Steps to be taken within 3 days. The next paragraph. You have a miss case?
Lordship, yes.
Yes, sir.
We are asking for. Lordship, we are asking for.
So and so. Where's the miss case?
Miss case number 33. Lordship. Sorry. Miss case 24.
Of 2024 in CRP number 33. So this is an application for staying the operation of the impugned judgment and order dated
2/12 to 24. Lordship.
2024. Passed by the court of the Additional Deputy Commissioner, bracket J, District Judge, West Garhills, Tura, in Miss Civil Appeal number 2 of 2023, arising out of Miss Case number 15 of 2022, in TS number 5 of 2022 stamp. Next para Mr. K. Khan, counsel for the petitioner submits that the petitioner, applicant as plaintiff, had instituted TS number 5 along with an application under Order 39 Rule 1 and 2 for interim injunction, and that the learned trial court, on hearing the parties, have been pleased to pass orders directing for maintenance of status quo on
6/7/2023.
6/7/2023 stop. Against the said order, submits an appeal is preferred before the court of the Additional Deputy Commissioner District Judge who by order dated
2/12/2024.
2024 has vacated the said SETSCO order. Stop. It is contended by the Senate Council that the factum of possession, has been established before the trial court, and the only doubt that remains is with the wrong quotation of the dark number concerning the said suit property. Therefore, please the interim that the status quo be restored. Stop. Having heard the council, for the petitioner, stop. It is noted that the trial court had recorded the factum possession, and also the other appellate court, which has observed that the pata number given, or the dark number given, so pata number is the same, is not consistent. For which reason the status quo order was vacated. So, however, in interest of justice and to it is directed that, however, in the interim directed that status quo be maintained as on today. Stop. It is further provided that the parties shall not change the nature of the suit land in any manner till the next date. Yes. Stop. Next paragraph. As the order has been passed in absence of the opposite party, so respondent the at liberty to seek modification or alteration of the order if so required. Just answer.
Item number 2.
Oblige, Your Lordship.
Yes.
With please, my lord. My lord, this is a contempt petition for non-compliance with your lordship's order dated the page 10, annexure 1, my lord.
Page 10, next one. What does the order say?
In your lordship, there was a direction to the respondents to pay the pensionary benefits to the petitioner within a period of 4 months, my lord.
When is the order passed?
12/06/2024. That 4 months has been lapsed, my lord.
You must LD Sama. Your name?
A. Sangma, my lord.
A. Sangma. Yes, Mr. A. Sangma. Issue notice. Returnable in 4 weeks. Steps to be taken by the said post within 3 days.
Grateful, my lord.
This
Item
also.
Item number 3.
For instructions for affidavit. Yes.
This is the 5th time, my lord, we are before this honorable court.
5th time?
Yeah, my lord. My lord, we are aggrieved. This is regarding that boy who has applied for SF10, my lord, and then
involved criminal cases.
Yes. Now, my criminal case acquitted, my lord. He has not even charge sheeted, my lord. Now, my lord, we have filed a representation, and on page 67, my lord, they have disposed our representation.
What did he say in the representation?
NHA 13, my lord.
He say?
My lord, with reference to the above on producer of all the available record in this office, I am to inform you that the matter has been earlier disposed of. White office BO number so and so, and the undersigned after 3 analysis of all the High Court's order, Honorable High Court's order, and the order passed by my predecessor, the conclusion of not considering your appeal for appointment in SF10 may be read as final. Yeah, so I am challenging this order, man. Notice.
Counsel petitioner. Issue notice, Mr. Khan, the representative on behalf of all respondents. No further notice called for this matter after vacations. 1 week after vacations for instructions affidavit. No.
Item number 4. May I please your lordship? Your lordship, the petitioner in this case aggrieved by the arbitrary and discriminatory action of the respondent authority, denying him pensionary benefits under the old pension scheme.
Retirement benefits under the old pension scheme?
Yes, your lordship. Your lordship, the...
When did he retire?
Not yet retired.
He's serving,
Your
madam.
lordship.
He's
He's still serving. While allowing other situated individuals, your lordship, to avail the pensionary benefits under the old pension scheme, your lordship.
How do you say that discriminated against you?
Your lordship, other employees, your lordship.
Where's the order? we've been put the new pension scheme. Now, where's the order we've been put in new pension scheme and the other similar situated?
So the other similarly situated, Your Lordship, they were approved, their regularization were approved after the cabinet decision, Your Lordship, in the year 2022. Then under that order, Your Lordship, these ad hoc employees were allowed to avail the pensionary schemes under the old pension scheme. Whereas my service was regularized in the year 2015 after intervention of this Honorable Court. As such,
Where's the order of this court? You annexed it?
yes, Your Lordship. Page 30, Your Lordship.
You have to show that you're similarly situated. That is the thing. 30. That's all.
Your Lordship,
So after this order, when you regularized?
in
2015,
the
madam.
Where's the order
2015, Your
regularized?
Lordship. Page 48, Your Lordship, Annex 9.
Page
48.
Yes. No, nothing about a pension, only brought a regular service.
Yes, Your Lordship.
Yes, MS Colney.
My lord, the petitioner is stating that the petitioner is being allowed pensionary benefits under the new pension scheme, my lord. And the allegation is that those people who have been regularized in 2022,
Afterwards, yes.
they are getting the old pension scheme. But there is no document to prove that they are getting under the old pension scheme. That is the allegation they are making in the writ.
In 2015, that means...
After the new pension scheme,
you're
2010.
working for 15 years, huh? That
My
means
lord,
2000
so my
years.
lord, everything has to be prospective, and whatever they are alleging, there is nothing document proof to say that they are
You
the
file
new.
affidavit
My
then.
lord, we'll take instruction. I'll accept notice, my lord.
Heard, MS Arkhatian issue notice. All respondents.
For all, my lord, 1 to 5.
Then the GH present, except on behalf of all respondents, no further notice called for this, so on and so on and so forth. Instructions affidavit.
Highly applied.
Item number 5.
This is also, my lord, second time that we are approaching before this honorable court, my lord, where my husband, they have alleged, my lord, that my husband has resigned, my lord. The impugn order, which we are challenging, my lord, is on page 55.
Yes.
The second last paragraph, my lord, however, it can be seen from the relevant documents that so and so, my husband, my lord, has tendered his resignation on so and so, and subsequently his resignation was accepted on so and so date.
So you resigned, so?
No, my lord, we are saying he has not resigned, my lord.
How he could do that is
the signature.
Now you look at 1993.
1993, my lord. That is what, my lord. We have communicated. There are a number of communication that we have made to the department after his death, my lord. Now, what happened, my lord? We are saying that he has not resigned, and the signature, my lord, the alleged signature is not my husband's signature, my lord, and we have placed that.
How are we going to?
That is what exactly, my lord. That is our case. The department.
Why should the state say that he's not resigned? What did it gain? Nothing.
My lord. If he has resigned, my lord, his signature should have tallied, my lord. First thing, and that has to be examined by an expert, my lord. They have not sent it to the expert, my lord, for giving their opinion, my lord. Let notice go only, my lord.
He had resigned way back in 1993. After his death in 2018, the wife comes and says that he has never resigned. And the signature is fake.
So, that is what we are
During
saying.
his
The signature
lifetime,
is
there
fake,
was
my
no
lord.
such challenge.
If I can have
Okay, let him take notice.
We'll take notice.
Yes. Cut Mr. SD Constitution issue notice. MSD Yangi Leonard AAG with so and so pen except to have all respondents. No further notice called for. Just out of vacation. Sorry, affidavit.
Item number 6.
We just have it at the end of the board. There's not a miscase that's come on board, Mr. Sen. You given copy to Mr. Nongpur?
Yes, morning.
It's
I
only
have
one
some
time for instructions.
For show cause, Lordship.
You file on Monday, we take it up.
Lordship, only thing, my lord, so far I am concerned, my lord, I have filed an impleading application.
But
My
you
lord,
already
we are,
impleaded in the main petition.
no,
itself.
that's what, no,
number 5, Lordship.
no, that is what, my lord, I'll have, no, my lord, respondent number
Who are
5.
you? Let's see the file. Let's see
We are the electors, my lord.
Exactly, but then you
Electors. Now, my lord, respondent number 5, my lord, it is a body, my lord, of customary administrators, not exclusive body of the electors.
Lordship, kindly see.
So what's the difference?
My lord, there is a difference, your lordship. It is a case, my lord, where the electors has, my lord, withdrawn their support. And it is, lordship will look into the record, I have annexed that order. It is solely on the basis of these electors, my lord, the proceeding was initiated. How can I, my lord, be not a party? I have come here before your lordship with an application.
See, 1 second, Mr. Sen.
Lordship.
See this, let's see the main petition.
Can you come to
The
page
main
60?
petition. Let's see the cause title. Sanjuk Nongsan Saraj.
Yes.
These are not electors.
My lord.
Lordship, kindly
This
come
is
to
not
page
only
68.
electors, your lord. This is a body of all customary administrators here, including handmen and all. This is not an exclusive body of the electors, my lord. This is the problem here. And secondly, your lordship will see 6.
But you cannot.
One of the.
See, 1 second.
Lordship.
Will your voice not be heard through respondent number 5 in this main petition?
Absolutely.
No.
No.
Yes, Your
No, I'm not saying that, your lord.
Yeah.
What I am pointing out, your lordship will see 5 is the body, 6, one of the elector, they have impleaded. They have left out the 5 because they know very well these 5, my lord, that matters. They have withdrawn the support, and that's how this order has been passed. That's how we are relevant.
Lordship, 5 and 6 are the complainants before the district council.
They are relevant, and
Lordship,
we are the
kindly-
one we have withdrawn
kindly
the
page 68,
support.
Lordship. Kindly come to page 68. This is the representation filed by the respondent number 5. Now the Sanjuk Nongsanchar, Lordship, it comprises of the linked also, Lordship. Who are the impleaders, who are the interlopers in the instant application, Lordship.
Lordship will see the district council's order, Lordship will see. District council has not referred to this organization. District council has referred to these 5 lindos.
Where is that order?
That order, my lord, my impleading application.
You don't next that order in the.
My lord,
Lordship, that was not.
they have not, your lordship. Many facts were not placed before my lord. I'll point out. Annexure 1. Lordship date 2nd December 24.
Lordship, this order was not supplied to me, Lordship. I had made a representation before them.
My lord, in the opening paragraph, the matter came up for consideration before the executive committee in response to a petition filed by the Lindos raised electors and Langsam Nongpo's readership. Such and such, again such and such. No, my lord, it is these 5 Lindos, they matters a lot, your lordships. And this organization is not an exclusive body of the, my lord, electors. And they have, lordship will say, conveniently, they have impleaded one Lindo, perhaps with them, as a party, but
Why
left
he
out.
supporting
Exactly, my lord. That's
He's
why,
a
my lord, I have taken the
complainant- he's a
initiative.
complainant. He had submitted representation.
And we have withdrawn the support, my lord. And that withdrawal has led to this order.
Now, when it was support, was he given adequate opportunity to?
Well, that will
I
come, my
felt
lord. So far, I am a concerned. Still now, I am a stranger. Unless your lordship give me a entry. Now I have placed this order before my lord. Even lordship could have done it without application so moto, my lord. Now I have come up with an application. Implead me, your lordships. Once your lordship implead me, my lord, then I will have a say on the matter. But right now, I am a
What's the matter?
stranger.
Why is not coming up your matter? It's been filed, you said.
It's already cleared, right? It's supposed to come.
We'll have after some time.
Yes.
End of the board, yes.
Ajab, I'm only praying that if I may be allowed to find my show cause to these applications. It can come on
End of the
Tuesday.
board, wait.
But in the,
Be patient.
my prayer, my lord, if I am allowed, I can also file a thing by tomorrow.
Daily item number 1.
Civil Division Lordship, we have filed a miscase for condoning the delay of 47 days. Steps
What, have you taken steps?
Lordship, steps have been taken.
But not received.
Delivered, Lordship. I may be
No,
allowed
not
to.
delivered.
But the online status is saying it's delivered. I may be allowed to
You
file
file.
the service after.
Yes, miscase number, CRP number 19/2024. As they submits that sole respondent.
Lordship, 2 respondents.
The respondents have since received notice. He prays without to place the same. The factum of survey affiliate plays allowed. Place when?
Lordship, I have it after.
This up. This also. We'll give the date.
Item number 2.
What's it for today?
Notice was issued on the last occasion to one should pay for time. Last occasion I paid for time.
No, I mean, what's it for today?
Oh, for hearing on the...
Not that last time you paid for time.
Only notice has been issued, my lord, in this on 6.
What's the matter about?
Here we have come against rejection of condemnation of delay in arbitration matter.
Can be taken up for hearing.
Yes. How many days delay? But delay in arbitration matters, whether that is a big question again.
Yes.
But then there's some Supreme says yes, they, but then whether Section 14, that is an interesting case.
This is under the old act, 1940 Act.
Old act.
Madam.
Yes. You then when do you want it to be heard?
I am ready today also, my lord.
Records.
I've annexed most of the papers otherwise, my lord.
Entire record is here along with the petition.
End of the book.
Any urgency?
As such, there is no urgency.
We will have after vacations then.
Not ready.
It was passed 2018. The award. What is passed 2018? Then it should have been filed.
2018 order.
It was an ex parte
Well,
order.
in spite of a clear direction of the Honorable Court that the matter will be taken up for hearing positively, they prefer not to appear before the court. So, court had no other alternative than to proceed with the hearing. Award is of 2003, my lord. 2003 award, and the hearing, they filed petition for setting aside the award. The matter was going on and on and on. Then finally,
2003 to 2018.
2018, the matter was heard. That also court has given specific order that on the next date, hearing will be taken up positivly. If any party is absent, it will proceed. In spite of being present and knowing about their order, they failed to, they don't appear on the date of hearing.
Yes. I remember. That last time when he moved, he said he had resigned.
But I resigned at that point.
Resigned after the hearing date. Hearing was in July, and the council resigns in November.
Yes,
No explanation why they did not appear.
Submit that as a matter concerns me a point of law. But facts will come also anyway. It's the same for hearing on so and so.
After vacation.
Item number 3.
Same thing, it's a correct number.
But even it was award 2003, now with the new,
Here what
the
happened,
new,
it was made rule of the court in 18, my lord.
whatever this,
Ex parte order,
the
they never
face of the
informed
court,
us.
Mr.
And not only that one, there's another aspect, my lord.
Well, the amount has already been paid. Only thing they are disputing is the interest. That court has post award interest. The law is a subtle lawyer.
They wait for 4 years for decree.
It is for the court to prepare the decree. Once the decree is prepared, we have gone for execution.
Order was passed in 2018.
Yes.
Then
That was an ex parte order.
Another old act made order for court 22.
It was made, there was an order for making rule of the court in 18, my lord.
It was
They have
passed
to- they have to-
22.
They have to get a
The
decree.
decree was prepared in 22.
22, my lord.
In between that, because of this transfer of the judicial officer, and then lockdown period, the court was not functioning for almost 2 years, and then decree was prepared. After that, the decree was put on execution, and it is not legal requirement on the part of the petitioner to inform the council. The only ground, your lordship, they are challenging is that limitation to be counted from the date of their knowledge. But in this case, notice was duly served on them. So under the Limitation Act, it will be from the date of the order.
15 lakh rupees award or 18 lakh rupees award.
See, 15 lakh, around 1,003, 15 lakhs will be, in real terms, value will be more than 1 crore now. Buy property now, what was available 1,003 for 5 lakhs, the same property we buy now be how much. So money is all relative. You take inflation into consideration.
15 lakhs award, my lord, because of their negligence, now it has come to more than 2 crores. Department is paying.
Yes.
Item 4 and 5 are contempt. Appeal has been preferred by the state against the main order, and we are preferring the appeal.
Which matter is this?
Matters also, my lord.
My lord.
What order is this?
My lord,
This is work charge establishment. Work charge establishment giving the implies.
When's the appeal coming up for consideration?
Yes, my lord.
When's the appeal coming up?
Next date of appeal.
Next February, my lord. February, my lord. After vacation.
February.
I mean, post this matter after that. Yes.
Your Lordship, as per Your Lordship's last order, Your Lordship, we were supposed to implead necessary parties, Your Lordship, in the contempt petition.
Have you impleaded?
Yes, Your Lordship.
This is where's the miss case? Okay. Number 8. Number 8. Is miss case number 8?
Yes, Your Lordship.
Yes. Right, that is an application for impleading Shri R. Swear, Secretary, Finance Department, and Shri P.W. Khera, Secretary, Public Works Department, Roads and Buildings, in the main contempt application. Any objection to impleading?
No, my lord.
No, my lord. No.
Yeah, so for the reasons given therein, the said two officers shall be pleaded as respondents number 2 and 3 in the main contempt application. Registry to make necessary corrections. As a matter as a contempt application, notice to go to the newly impleaded respondents. Yes. In the main case, view the order passed, miss case disposal, pass also. Petition to take steps for serve notice on newly impleaded respondents number 2 and 3. Yes.
5.
Lord,
Item
5 is same matter, my lord.
Impleading here also?
Yes, Your Lordship.
Just the officer name will be different, my lord.
Officer's name different.
There will be different parties that will make a point.
Your Lordship, in this item 5 also we filed we've also want to strike off the former chief engineer, Your Lordship.
Who is this? Okay, wait, take down the way. This is an application for impleading. But the same application.
My lord, in the second case, the second respondent has retired.
No,
So
okay.
therefore, they have made the present officers as respondent.
Yes. Application is using the same one, R. Swear and so. Mr. Pasante further submits that the original respondent, that is who is that? J.V. Lingdo?
Yes, my lord.
Respondent number 2, Shijino may be struck off from the area of parties as he since retired. And ordered accordingly, yes. Restrict to make necessary corrections, striking out son number 2 and impleading the new two officers as respondent number 2 and 3. Yes.
Including the
May have up to five
including the current chief engineer, Your Lordship.
2 and 3.
2 and 3. Yes, and main case steps on the newly impleaded respondents 2 and 3. Yes, list the matter after on 10th February.
Item number 6.
My lord, in this case, my lord, the order has already been complied, my lord. An order has been passed.
Yes, MS Hajong. You are aware?
Oh, we haven't received any
You
comments.
haven't received anything?
We'll give you a copy, my lord. This one.
Yes, give a copy of that.
My lord, we will supply the
Yes,
copy.
Mr. M. Shinkon submits that the order stated to have been violated has already been complied with. Stop. A copy of an order dated 25/11/2024 is produced before the court. Therefore, M. Hajong appearing for the petitioner, please will have to obtain instructions. The copy of the order is also handed over to her. This application is.
Obliged.
Item 7.
Your Lordship, I pray if I may be allowed to take a first step on respondent number 5, Your Lordship.
5 and 7. Only 5 or 7 also.
Only 5, Your Lordship.
7 is served. 6, 7's whom? You have appearing. NH? Okay. 5 is whom?
Service contractor.
Yes. Yes, letter comes of petitioner. An officer indicates that a service is not complete in respect of respondents number 5 and 7. Stop and letter comes of the petitioner. So praise is allowed to obtain the correct address for respondent number 5 and to take fresh steps. What you file affidavit? You already file.
State has filed, Your Lordship.
You want to file?
It appears only for 40 minutes.
Yes, Dr. Elmosi appearing for respondent number 6 submits that they just formal parties and no affidavit forthcoming from the said respondent. This after vacations, as a petitioner is allowed to take fresh steps on respondent number 5. This after vacation for service reports on both respondent number 5 and 7. Yes.
Obliged, Your Lordship.
Item number 8.
Lordship, in this matter, we'll file a rejoinder after vacation, Lordship.
How many times you prayed?
Second time, Lordship.
For the 2 weeks as prayed allowed for rejoinder.
Hello,
9.
Madam, the respondents are yet to file their affidavits, Madam.
Yes.
The respondent has not.
Who are the parents for the 1, 2, 3?
Actually, I'm for 4 and 5.
Hmm?
Lordship, on the last day, the petitioner has brought on record the complaint, which I've made a submission that she has not disclosed that in the petition. Lordship, as per the submission, as per the instructions of Lordship, the representation is pending before the state respondent.
My Lord, the representation was filed in the year 2023, my Lord, but till date nothing has been released to the petitioner, my Lord.
Your Lordship, meetings have been held with the petitioner and the private respondents, Your Lordship. No positive outcome has been was arrived at, Your Lordship.
You're a head teacher.
My Lord.
You're restored as head teacher, or you lost your job.
She stopped going to the school, my Lord, because of nothing has been paid, my Lord, till date since the year 2004, my Lord.
You're for 4 and 5.
For 4 and 5 are managing committee.
You don't file affidavits yet.
Lordship, my submission at this stage, because since the matter is still pending before the respondent, Lordship.
Let them file their affidavit, my
Lordship,
Lord.
the petitioner here is also not a sanctioned teacher, Your Lordship.
No, that's besides the point. But if there's, are you examining the matter or not?
Lordship, we had this.
You file affidavit then, whatever the.
Lordship, the managing committee has also filed a claim petition before the state respondent counter. So, Lordship, let the respondent file a detailed order, Lordship. Maybe the matter may be disposed of.
Let them file their affidavit at least, my Lord.
File affidavit.
Lordship, another submission. She's not received salaries from 2004. Now, at this stage, she's coming before the court, Lordship. And she's not even a sanctioned teacher, Lordship. So if she can go back, we can participate before the respondent.
File the affidavit, then we can give a decent burial. Right.
Lordship.
Yes. Further 2 weeks' time is allowed to the respondent to file affidavits. Yes.
Item number 10.
24 matter though.
May I please, Lordship? I am referring for respondent number 7, 8 and 9, Lordship. I pray 2 weeks time to file affidavit, Lordship.
You already were given time before. Don't want to file.
I will file, Lordship.
Today?
After 2 weeks, Lordship.
Yes, Mr. Mansuri.
Well, Lord, I have already...
How many times is prayed?
2 times, Lordship.
2 times? And your state?
I have already filed.
You filed a joiner?
I have filed.
Is it important, the affidavit from the 7, 8 and 9?
7, 8, 9, because they are existing secretary holding the post.
Yes, Mr. A. Sangma.
M.R. Marak, Lordship.
Sorry, M.R. Marak. Mistaken. Yes, for response 7 to 9. Place was not for 2 weeks' time. to file. I had expected that on the next day the affidavit should be on board. Yes.
All right. Answer received.
11.
Here, Your Lordship, the state respondents have filed their affidavit.
Yes, Your Lordship, we filed the rejoinder affidavit, Lordship. Some
Yes,
more time, Lordship.
yes, yes. 3 weeks time allowed to the petitioner to file rejoinder to the other file the state respondents.
12, 13, and 14 are also similar matters.
15.
Yes.
My lord, we need some more time to file the rejoinder, lordship.
Yes. 3 weeks for the time is allowed for the rejoinder.
Deeply obliged. Deeply.
16.
Yeah, I'm praying for some more time.
What is this?
Lordship, last opportunity may be granted. This is the second round of litigation, Lordship. This is second round of litigation, Lordship. And this is the 6th time they are paying for time.
Second, what is the matter about?
It's matter all about SCP, Lordship.
Regarding?
Regarding SCP, Lordship, I was not granted the SCP. Then, Lordship, by judgment and order dated, Lordship, 13/4/2023, my petition was allowed. Directed the respondent to pay my SCP, Lordship. Then they have not paid. They have not complied with that order, judgment and order.
So what do you file? Why didn't you file contempt then?
Lordship, they were giving me always false hope that they will be complying with the judgment, with the said judgment, Lordship.
He's serving as what now?
Lordship, I am serving as
He's asking for MECP.
Naib Subedar, Lordship.
This is a straightforward case, Dr. Majika. He's about 94, you remastered. Then, as per the 5th Pay Commission, he should have been given relief service, same post, all that thing.
Well, there is some instruction, my lord, but I've not been able to digest it.
Because he be entitled to his ACP, MECP, there's no doubt. Why denying him?
It has been
Well,
1.5
the matter
years.
comes up on Monday. But there are some instructions I could not go through. Monday, my lord. I think it can be.
Dr. Mazika submits that praise that Monday to be able to praise the instructions received. Yes. Well, that's right. If it's upon 94 is remastered, then the same is the same formula of everyone.
Yes, in fact, there is some issue. I have to understand on Monday, my lord.
17.
Affidavit file.
No, Your Lordship.
Why?
Can you pray for some time, Your Lordship?
How many times you prayed?
2 times, Your Lordship.
Sure.
Yes, Your Lordship.
No.
Well, by looking at the conduct, we had prayed for ample time for affidavit.
Your Lordship,
In fact, there remains
It's not
nothing.
2 times.
More than 2 times.
Yes, 27/9. Then 28/10, further 2 weeks. Then 18/11, 1 week. Then now third time on 2011. Yes.
I have an objection.
Your Lordship, the affidavit is ready, but we need to obtain the signature of the respondent.
So what are we to do? We'll go to his house to get signature. Signature is supposed to become obtained for oath commissioner. Yes. Further 2 weeks time granted. In interest of justice for affidavit. Yes. Is thereafter.
18.
To be obliged.
Your Lordship, our affidavit here is ready, but we filed it in the course of the day. The signatory was not there, Your Lordship.
You're appealing for whom?
State respondents.
You read your affidavit file.
It's in the process of.
What's the matter about?
It's regarding their
Interim order dated 24/10/2018 and 29/10/2020 passed by the Board of Directors of Meghalaya Transport Corporation, Your Lordship, regarding the 5th pay revision.
Okay. You find the course of the day.
Yes, Your Lordship.
Ms. T. Anglin AG would so submits on behalf of respondent number 1 submits that the affidavit on behalf of the said
State
respondent will
respondents.
file state respondent file the course of the day. You? Yes, Mr. M.U. Ahmed for Respondent number 2, praise for a 2 weeks time hybrid. Yes, thereafter and so on.
19.
Yes, Your Lordship.
Please, Lord. Lordship, this matter I'm praying for time, Lordship, to file the affidavit for the respondents.
Regarding regularization, Lordship.
Yes, as prayer for a 2 weeks time granted.
Obliged.
20.
For affidavit, my lord, I'm still awaiting instructions.
When was it filed? November?
In November.
November. Before that, it was filed in DB.
Then what happened in DB?
Then from DB, they have directed to file it in a single.
What's the matter about? Seizure?
No, this is for a seizure case, but a release of security deposit of the truck.
Otherwise, also it appears that they have a good case. Here, what happened, my lord? The beetle nut was seized and truck was also seized.
Truck was released.
My lord, beetle nut
released.
Now the tribunal has come to finding that there is no evidence that this is a smuggled articles, so discharge the beetle nut owner. Now his truck is still stuck.
When was the seizure done?
Seizure is of. But only mistake I'll say on their part is that they did not follow the procedure. My lord.
So when was the seizure conducted?
16.
So your trucks will be in what condition now then?
No, truck
has been released, my lord.
Only a
Only
security
the-
deposit, money.
Oh.
Security for
Only
provisional
the bond
release.
which is submitted, my lord, that is pending.
What amount?
That is nearly 5 lakhs.
That's a small amount.
But on next date.
Allowed further 2 weeks time to file affidavit. Yes. Yes, upon also.
21.
Much obliged.
No, we'll be filing an affidavit in the course of the day.
This is MECL.
Yes, my lord.
Yes, Mr. A.S. Pandey. For response to this post submits that the will file of course the list the matter for after 4 weeks for rejoinder if any. After is also for rejoinder if any.
22.
The matter pertaining to the challenge to the special managing committee which has been constituted without any meeting and without any term also, Lordship. I have filed a stay application also. Respondents were supposed to
Lordship,
come up
will
with instructions.
require some time to file affidavit. This is the second time, Lordship. Let's come for the second time.
Similar to your Lordship.
There's no urgency.
Lordship,
There's no urgency.
Lordship, the urgency is that for the last 3 years, since 2021, this particular school does not have a regular SMC. In the meantime, it was under administrative control.
Now
Some people have made a bogus resolution and forwarded it for approval as a regular SMC. Now, instead of approving it as a regular SMC or otherwise, the state respondent has approved it without any time period. The same members as a special SMC. Also, the rules provide that special SMC, if at all is there, it's only for 3 to 6 months. Now they have given it for until further orders, and Lordship, the situation in the school has become is worsening from time to time. My humble submission is, Lordship, if at all there is a Lordship, there is no managing committee, that is the administration right from 21. They instead of going for ad hoc and administrative control and then
let there be a new constitution.
Proper meeting and-
Yes, you are agreeable to that.
Your Lordship, if this matter can be taken up, we'll file our.
End of the board.
No, not at the end of what, because the conducting counsel, Mr. S. Sen, is on sanction leave, Your Lordship.
When it come Monday.
We'll file our affidavit, Your Lordship.
It's after it's ready. What's the position? Is it correct? Is it just functioning with a special managing committee which has not been duly constituted?
Initially,
My
there
lord,
was an ad hoc.
my lord, I only draw lordship attention to the prayer, my lord. And the
Yes.
petition. Page 30, my lord. 30. Also, kindly see prayer C, my lord. So, oblique motives, my lord.
Direct discount?
At page 30, prayer C.
Yes.
Direct the concerned state respondent to pass necessary directives for convening a general public meeting, inviting all the stakeholders, parents, guardians, etc. of the state school for the purpose of constituting a regular managing committee as per the rules, and in the interim to direct the state respondent to allow the ad hoc committee, which was approved by the order dated 22/10/2022 to
This is his ad hoc committee 22.
My lord.
Now the new ad hoc committee constituted when?
That has been constituted on 14 October 2024.
Then
as a
it's all
special
right.
SFC.
Same thing.
No,
See,
this
asking
Ad
you
hoc
can't.
committee is not my committee, Lordship.
Whatever it is, we can't replace one ad hoc, not ad hoc.
No, Lordship.
even
First ad
even
hoc-
managing committee.
Lordship, first ad hoc committee was already.
There are file affidavits,
come
yes,
up,
though strong reservations have been expressed by Ms. S. Deb with regard to the continuance of special managing committee for the said school in question. Stop the respondents, said respondents by Ms. Ailingma and respondent number 4 and 5. 5 and 6.
Only 5.
Only 5. Yes. Pray for and allowed 2 weeks time to file affidavit. Yes. This immediately on reopening.
23.
Lordship, my lord, in this case, my lord, in fact, I am required to file an affidavit.
Why? If it's lapsed by your own order, we're not going to interpret anything, Mr. Sen.
No.
You gave an order that is on, the order you gave was on 5th of May, you know, 5th of August. Then
Well, there's some
it's
problem.
conditional suspension.
In fact, when my learned senior friend they filed this case, there was some defect in the writ petition. So only I am holding that defective copy, my lord. That corrected copy has not been served on me.
That
Has not served. So what I suggest, my lord, let it come on the first during this January, my lord. I'll serve in advance. I'll give him a copy of the affidavit.
but
Lordship can decide.
if he's suspended as per your own orders, you see that
No, not given.
the order is 5/8/2014. You just see it. It's there with you.
56.
5/2014, page 56.
And under rule CCS rule 10, sub-rule 6 and 7, since no review has been done prior to expiry of 90 days, then automatically that goes. He has to be reinstated.
See that order is annexure 10. That is what. No, that's the only thing. I'm leaving it at a face value only, in person or so and so for under 90 days. So after 90 days, you don't need orders of the court or orders from the executive council. Anything. He or from registrar, he automatically reverts back.
In spite of my application also they didn't do. Then I have approached.
How do we address this? You get instructions. We'll have it on Tuesday.
The rule is very clear. CCS rules. Your
Yes.
Lordship.
Today, Mr. SN
Will he give me a copy?
went for the respondent university submitted due to the defective nature of the petition in his possession. He could not obtain proper instructions. So it accordingly permitted to obtain instructions. This is the matter on Tuesday. Tuesday is the last day.
Tuesday.
You'll be there. 17. Because see,
But
you
in
can't
fact,
escape from the
corrected
order.
copy has been given. Same copy, I think.
Doesn't matter. You
Hearing.
see, Mr. Sir, how can he escape that? It's
Your Lordship, the
it's their own
CCS
order.
rule is clear. He has
No,
got it.
no, it's their own order. It's not a question of you trying to enforce anything. Yes.
Hearing. Supplementary list 7.
Yes.
Much.
Yes, Mr. Kumar.
My lord, the similar judgment is page number 23, my lord, on annexure 6.
What's the matter about?
This is a promotion matter, my lord.
It is known as this.
Promotion to the rank of warrant officer to Naib Subedar, my lord.
One officer to Naib Subedar.
My lord?
Yes. Yes.
Similar judgment is page number 23, my lord.
Where's operative part? Page 23.
My lord, page number 28, my lord, paragraph 13.
Okay. Yes.
May I, lord?
Please read. Yes.
This court is not permitted to approve of the action of the respondent as to why, when the petitioner was sent on extra-regimental duty to headquarters IGR North, Nagaland, Kohima, as intelligence JCO in public interest on 10/4/2010, within the same organization. The ACR grading earned by him should not be considered for promotion. Legitimate right of the petitioner to consideration for promotion cannot be certified by involving such arbitrary executive instruction, and his junior could not be preferred over him owing to such fraction circumstances which was not in his control. Since the respondent have not deputed the ascertain of the petitioner that he earned ACR grading of very good stock outstanding during year 2010, 10, 11, 11, 12 and 12, 13, the action of the respondents in not granting promotion to the petitioner is declared to be illegal, arbitrary and discriminatory, being violative of Article 14 and 16 of the Constitution of India. Now, my lord, paragraph number 14. Consequently, the impugned order dated 1/1/2016 is quashed and set aside, and writ petition succeed and is hereby allowed. The respondent are directed to consider the case of the petitioner and to grant him promotion with effect from 1/4/2013, when the post of Subedar GD became vacant, with all consequential benefits together with interest at the rate 9% per annum, my lord. The whole exercise shall be completed within the 3 months from the date of receipt of the copy of this order, so as to make compliance of this judgment, my lord.
Yes, Dr. Mojika.
Well, I've given a note, my lord, if lordship kindly.
This judgment doesn't cover his case.
It will cover only one aspect, my lord. The other aspect is lacking in that, my lord.
Yes.
But here, a few facts, my lord. The petitioner was enrolled in Assam Rifle in 87, promoted to Havaldar in
Yes,
2000.
given a copy to this Mr. Kumar.
He is not here, my lord. No, even his juniors are not here. But these facts are not.
Mr. Kumar, this DSGI has given a small list, a note on the case.
But my lord,
What's happened to him?
Otherwise, also it can be disposed of.
Yes.
Says in the WhatsApp.
Yes. Okay.
My lord, there are two aspects. My friend was reading to this judgment, my lord. Now I'll draw lordship to para 11, my lord, of this same very judgment.
Yes.
It says, my lord, the respondents in para 4C of the affidavit have also admitted that the petitioner earned 4 ACRs while working at so and so, so and so, so. Assertion of the petitioner in memo of writ petition that during the period he was awarded very good outstanding benchmark in his ACR APR has not been disputed by the respondent. So in that case, my lord, he was meeting the qualitative requirements. In this case, my lordship kindly sees. In my chart, and I'll correlate with the affidavit, my lord. In 2019, he had 3 points.
In your affidavit?
My lord. I'm referring to chart, my lord, but I'll correlate with the affidavit also, my lord.
Yes.
2019, he had 3 points only.
High average.
2020, he had 4 points, my lord.
Yes.
2021, he had 4 points. Then 9 points and 9 points.
Yes.
Now, if I may take a lordship to the affidavit, my lord, my affidavit.
So what about the part is deputed?
My lord, even if that is considered, my lord, even if we admit that he is covered by the earlier judgment, but he is not meeting the qualitative requirement.
No, fine. We're not going to pass orders for promotion.
My lord.
Only that part when you're on deputation should be considered for the process of considering him whether he's fit for promotion or not. That's all.
That way it can be disposed of. But what the authorities will take into consider whether he meets the requirements. Otherwise,
where in the affidavit you said that?
I'll just paras page 5 is sub para E, my lord.
Yes.
Now, the petitioner's case had come up for promotion to the rank of Naib Subedar in the year 24 as per his seniority and was screened by the Departmental Promotion Committee. As per existing promotion policies, last 5 ACRs for the year 19 to 2023 was taken into account by the DPC of 2024. However, he was found to be ineligible for promotion due to lack of ACR APAR criteria. His mandatory field service reports, as per the policy, to be eligible for promotion to the rank of Naib Subedar, the petitioners would have earned 2 reports out of the last 5 reports from Battalion, Assam Rifle Training Center and School, National Security Guard, not applicable to GD personnel, forming part of the Assam Rifle team of any attached to Assam Rifle, whereas he had earned 4 ACR APAR out of the last 5 ACR APAR from headquarters 9 sector Assam Rifles while on extra regimental employment duty. Accordingly, the Departmental Promotion Committee did not recommend the petitioner for promotion and his immediate juniors were promoted. Now, my lord, because at the threshold itself, his promotion was denied because he had the ACR from the extra regimental employment duty, ERE duty. And that has been held by this Honorable Court, my lord, in the other decision. But in this case, my lord, we did not proceed further because there will be next step also, that whether he otherwise meets the requirement of promotion or not. So, my lord, your lordship disposes of the matter saying that ERE will not be taken into consideration, but his...
So, just come, ER will not be considered meaning?
But why he was rejected, my lord? I'll just take your
See,
lordship.
come to your chart.
My lord.
Okay, your the promotion was taken, that means if it was taken considered 19, 20, 21, 23, right?
My lord.
Fine. Then,
Now,
as per promotion policy record of instructions, ROI, promotion, so, last 2 reports must be from battalion ART, so, not applicable to. Now, he does not have these 2 reports, right?
my lord, your lordship, in the
Come to
table,
your chart only.
table below, lordship, see, 1990 he is from RR, so that is admissible, my lord. 2020 is ERE, and till 2023 is ERE.
So, this ERE is not admissible.
Was not admissible.
Extra,
But
for extra regimental what?
Extra regimental employment, my lord. ERE duty. So even if his ERE is taken into account, my lord, but he only had 3 points, 4 points, and 4 points in first 3 years. That will make him ineligible, my lord.
But it's been communicated all this lack of ACR. He'll have to come another case then.
It goes to another time, Mr. Marad.
He'll go to another thing. If it's not been communicated, then now consideration will come anyway. Yes.
Well, I'll just take your lordship to page 44, my lord.
Of
my affidavit, my lord.
Yeah.
Lordship, here at ABC, Havaldar to warrant officer, this is what is applicable to him, my lord. Now this says all 5 ACRs, that is from 16 to 20, should not be below very good.
No, now it's a one officer to Naib Subedar.
My lord, this is applicable to the 3 categories: Havaldar to warrant officer, Havaldar to Naib Subedar, and warrant officer to Naib Subedar.
Yes.
The last one, my lord, will cover him.
Yes, yes. See.
My lord.
All
Now,
5 in ACRs
should not be below
should not
very
be
good.
very, very good.
Now he is below very good in those, my lord.
It's just a high average. Now very good is how many points? Above 4 points.
Very good will be, my lord,
5 to 7.
8 points, my lord.
8.
My lord. 6 to 8. That your lordship will find at page 5 of my affidavit, my lord. Page 40 is also there, my lord. Page 40, the next chapter. Very good, 7 points, my lord. Grading between 6 and 8, 7 points.
1 second. Good to very good. Outstanding 8 to 10.
Grading between 6 and sort
Very
of 8.
good, 7.
7. Average 7.
But 7, that means, what about 4 to 7? And 4 to 7 is what? High average. No. Above average, high average. Grading between 6 and 8. Very good. Grading 4 and 6. Okay.
So, my lord, in my humble submission, this aspect can be left open for the department to consider, my lord. Whether he meets, otherwise meets the criteria or not, my lord.
Yes. Yes, Mr. Anything else to say?
Now, my lord, kindly see page number 22 of my petition, my lord. That is the rejection order, my lord. That is the impugn order, my lord.
22?
Yes, my lord. 22 of my petition, my lord. Paragraph number 3, my lord.
Yes.
Your client had come up for promotion.
Yes. Yes.
To the rank of National 2024. However, he was found to be ineligible for promotion due to lacking
Yeah.
of
Right.
annual
No, this we
confidential reporting
understand.
criteria.
Yes. Yes, we
My lord.
understand that. Yes. Take down. Then,
My lord.
Heard Mr. V. Kumar for the petitioners, on behalf of the petitioner, who submits that the grievance of the writ petitioner is with the impugned order dated 28 March 2024, wherein he was intimated that he had wherein the petitioner was intimated that he was ineligible for promotion due to lacking in annual confidential report criteria, within bracket, that is mandatory field service reports, inasmuch as per policy the petitioner should have earned 2 reports out of the last 5 reports from the battalion stroke Assam Rifles Training Center, etc. Stop. The Learned Counsel petitioner further submits that the petitioner, who is presently serving as warrant officer stroke GD general duty, is due for consideration for promotion to the post of Naib Subedar, but on account of the impugned, and on account of the stand taken by the respondents, his promotion has not been put up for consideration. Stop. He further submits that the case of the petitioner is also covered by the judgment of this court passed in judgment of the court dated 5/12 of this court, judgment of the court dated 5/12/2019, passed in WPC number 242/2016, wherein it has been held that the ACRs which were obtained by the petitioner while he was sent for extra capital R regimental employment bracket ERE for the relevant years were to be taken into consideration for the purposes of promotion, for purposes of the ACRs for promotion. He therefore prays that directions issued to the respondents to take into account the 4 years, that is 2020 to 2023 ACRs of petitioner which were on ERE for concession as a promotion. Stop. Next paragraph. Dr. N. Mozika on behalf of the DSI with so and so on behalf of the respondents has on the first part on the submission that the time spent, the ECR obtained while on ERE. Oh no, sorry. Has
On submissions
on submissions of the has no has concurred to that part of submission made by the counsel petitioner that the ECRs generated while on ERE duty be considered for purposes of promotion, but however has drawn attention of this court to the affidavit wherein at para, what para is this?
5C.
5E. It's not para this. 2. Para 2.
2E.
2 capital E. It has been stated that even if the last 5 ECR or stroke APARs for the year 2019 to 2023 are taken into account, the petitioner would not be eligible for promotion due to lack in the ACR criteria. Stop. Next paragraph. This court has considered submissions made by the legal counsel for the parties and also the impugned order dated 28 March 2024 against which the writ petition inscription has been preferred. Stop. An examination of the same at para 3 thereof clearly only speaks about the ineligibility for promotion of the petitioner was due to not having the ACRs for the required years from the battalion stroke Assam Rifles Training Center, etc. Para 3 of the impugned letter dated 28/3/2024 being relevant for the purpose of this case is reproduced here and below. This court name, which mark page 22, para 3. Just give small bracket. Stop. Next paragraph. Coupled with the above, at this juncture, this court has also examined the judgment placed by the learned counsel for the petitioner, wherein at para 13 thereof this court had directed that this court had come to a finding that the duty spent on ERE, right? This is on ERE. and the ECR grading earned by the petitioner therein, was it considered for promotion as much as it was service duty within the same organization? The said para, for the sake of convenience, is also reproduced here in below. Next para thereof. Accordingly, in view of these circumstances as seen here and above, the respondents are therefore directed to consider the case of the petitioner and for this purpose is to take to account the ACRs, to take account also the ACRs for the years 2020, 2021, 2022-23, which were where he was graded when he was on extra regimental employment. The impugned letter is therefore set aside and the respondent directed to proceed in accordance with law.
And some observation, if he otherwise is qualified.
Under the law, if he otherwise is found eligible, yes, on other parameters, yes, matter of instance disposed of, allowed and disposed of this.
Yes.
Second call. Item 6 of supplementary list.
Just 1 second. Let's see other hearing matters. Who's ready?
29.
Yes, Your Lordship, this is that matter, the pension matter, the year 89 to 99, that matter. I have filed one affidavit to bring on record the extension issued by the state government. That affidavit is taken.
Oh, where's the comment? Mr. Shulai.
I'll have to take instructions from the department also regarding this.
We'll note this. Yes, Mr. S. Marpan submits that affidavit for bringing on record the orders passed by this respondent number 3.
Yes.
And letter of respondent number 5 pertaining to the extension of the terms of deputation has been filed. Upon list this matter after vacation, enable the respondents to obtain proper instructions thereon.
Yes,
34.
Yes.
Please, Your Lordship, I appear for petitioner in item number 34.
Yes.
Please, Your Lordship, this is a case where the petitioner has been declared medically unfit on the grounds of tremors.
On the grounds of?
Tremors.
Or tremors.
Tremor.
Yes.
Yes. Please, if Your Lordship would have the review medical examination, Your Lordship would find that at page 31.
Yes.
Please, Your Lordship would find the reasons for unfit. Your Lordship would find them at final opinion, seriatim B, unfit on account of essential tremors.
Page 31.
Yes. And your lordship would note the date is of 15th of July 2023.
Yes.
Please, your lordship would now come to their guidelines.
Where are the guidelines?
Please, your lordship would have page 51. I'm sorry, 52.
Yes.
Please, you will see there's a heading minor acceptable defects. And if your lordship would have clause P of this, only tremors without any organic, clause P.
Yes, 1 second.
Only tremors without any organic cause. So your lordship will see that not all tremors render unfit. It is only, in fact, the minor tremors are allowed, and it is considered as a minor acceptable defect.
Only tremors without organic causes means?
Yes. Please, your lordship will see this is a minor acceptable defect. So
Yes.
therefore, the review medical board to see that what kind of tremor was I suffering from, whether it was a tremor without any organic cause or a tremor with an organic cause, which is not being done.
Yes.
And if your lordship would now have their guidelines for review medical examination, page 58. Please, your lordship would have clause G.
1 second. This is review. 1 second. This heading is called?
This is guidelines of review medical examination. This starts at page 54. Your lordship would find the heading at page 54.
Yes.
And if your lordship would now come to 58, these are the guidelines which are being laid out for the review medical examination.
Yes.
These are, in fact, if your lordship would just have page 57 first, paragraph 7. Following examples are cited for the guidance of review medical board.
Yes.
And then if you would come to clause G.
Yes.
Any tremor in hands or other parts of body, thyrotoxicosis should be ruled out and neurologist opinion should be taken. Please, your lordship, my specific submission here is that no neurologist opinion was taken here by the review medical board before rendering the petitioner unfit. And if your lordship would now have just one last thing.
Yes.
Please, your lordship, after 15 days, the petitioner got himself examined by the AIMS, Raipur, on 1st of August 2023.
Where's that?
He was admitted on 1st of August, and finally, after all the
Where's that report?
Yes, please, your lordship, that report starts at page 32.
32.
32. Please, your lordship would find the date here, date and time, 1st August 2023.
Date and time. Where do you get that?
Please, your lordship, the date is 1st August 2023, time is 9:48. And then your lordship will see that the detailed manner of tests that they have done. Please, your lordship would find them starting from page 35.
Yeah.
And your lordship would now find the final opinion at page 37.
Yes.
Please, your lordship, see somewhere in the middle it is written no tremors, no intentional tremors. And to show that from the typed copy also.
Yes.
Please, and your lordship, will see the final opinion is at page 38A. Patient is medically fit for recruitment to army. Page 38A.
Yes.
Your lordship will see that that there are in fact detailed tests conducted, which your lordship would find at annexure P4, page 39. If your lordship will see page 39, page 40, Page 41, if your lordship will see, even the diagrams have been made to show that he doesn't suffer from any tremors. Please, if your lordship will have page 41.
Yes.
So therefore, your lordship, in my submission is that at least one opportunity be given to him for being medically examined again. If he's not
When was
found
he
with that-
recruited? When was the recruitment done?
His lordship, the recruitment was done in the year 2023.
Okay.
I was initially before the Chhattisgarh High Court, which had given me permission to approach this court because Chhattisgarh High Court did not have the jurisdiction.
Yes.
Please, your lordship, I have annexed that order also. And the vacancy is still lying vacant.
Yes, Dr. Mojika.
What we have said in affidavit, my lord, in the first examination as well as in the review medical examination, on both counts, my lord.
Let's see affidavit. Where is that?
PS2, my lord. Subpara C onwards. That during the detailed medical examination, the petitioner was found medically unfit on grounds of digital tremors. Thereafter, the petitioner was informed by memorandum of unfit to appeal against the findings of the DME if he desires to do so. The petitioner appealed for review medical examination. Accordingly, he was referred to Assam Rifles Composite Hospital, Sukhobi, where on 11/7/23, medicine specialist further referred him to Jain Hospital, Dimapur, Nagaland for specialist investigation opinion. That on 15/7/23, the petitioner reported to Assam Rifles Composite Hospital, wherein based on special investigation reports of Jain Hospital, Dimapur, he was declared unfit on ground of essential tremors and his candidature was rejected for the recruitment rally. So twice he was found unfit, my lord. And moreover, my lord, as regard the fitness for the purpose of recruitment to army, my lord, which requires specialized training, the army authorities are the most competent authorities, my lord. Because a person may be fit for civilian purposes, my lord. Once there are two reports, my lord, in my humble submission, nothing further is required.
Two reports. First report.
I'll just point out, my lord. Reports are there in the writ petition itself, my lord.
The first report from the Assam Rifle report. Let's see both of them.
Please, your lordship would find a reference to that has not been provided to us, but that reference, your lordship would find that annexure P3.
Page 30.
Please, if you talk to the, again,
okay.
Page 31, paragraph 1.
No, this is the first one, or the review?
This is a review, my lord.
Where's the first examination?
First examination is...
Please, your lordship, that they have also not annexed with their counter after it. And we were never provided the copy of that because we are only given review medical examination.
You produce it, Dr. Mazika.
I'll produce it.
In the course of hearing, it's noted that the first initial medical report of the petitioner is not available on record. None of DHI directed to produce the same for the next date.
Right.
You produce it, yes. Let them produce it next date, yes.
Sure.
Because otherwise, as per from what we can see, that means there's nothing to stop you from having a review medical. But let's see the first one, whether it was, whether it was a detailed nature or something that required.
Yes, in fact, if your lordship will see the specialist opinion, that's also only of a radiologist and not of a neurologist.
No, we'll examine that. Let them produce the first.
Yes.
Yes.
Item number 6.
And also the detailed examination, the review medical. That's just a short report.
The review the complete report.
That's the complete report.
Complete report, sir.
Okay, yes. Yes.
Wait, please, your lordships. Now, my lord, as I was submitting, my lord, now, entire issue hinges on the withdrawal of support by these 5 windows. Now, it's true. They have made the organization, which is much broad-based. It is not the...
One first question. Was the complaint under the umbrella of the organization?
No, exactly.
That's what is going on.
No. It is only by the 5 windows, your lordship. Specifically mentioned of this right, these rights. Now, my lord, these are the documents, my lord, I want to bring to your lordship's notice, my lord. But right now, I am a stranger, your lordship. So, unless your lordship permit, other thing your lordship will see, very conveniently, he made one of the Lindo as a party. Perhaps, my lord, he is expecting that he enjoys his confidence. But he left out the other lindos. And now the lindos themselves, my lord, before these 5 lindos who had withdrawn the support and which has led to his downfall, your lordship, now they have come before this court, my lord, with an application for impleading. My humble submission, we may be allowed, my lord, as a party respondent in this case, immediately it's ready almost, my lord, application for vacating stay. We'll file the application for vacating stay. We ensure that he get the copy by tomorrow. We'll serve him a copy
have it
by
on Monday.
Monday.
We'll dispose of the matter.
And then the entire thing will be heard.
Lordship, allow me to file my show cause to the
You file,
application.
yes.
I'll file my
This
show
case
cause.
number 218 first. This is for impleading, correct?
Yes.
This is an application for impleading the applicants herein as necessary respondents in the. What is this? Is no, this one's 218 for vacating.
215, my lord, it's 215.
This is a application by the applicants name herein for impeding themselves as party respondents in WPC number 452 of 2024. Submitted by Mr. S.N. counsel for the applicants that they are absolutely necessary to be made respondents in view of the fact that the suspension of the petitioner was due to the complaints that have been filed by the applicants here and stuff. If Mr. M. petitioner prays be allowed to file a objection to the impleadment. Praise all this the matter on Monday for consideration.
I'm praying for Tuesday, Lordship. On Monday I have personal difficulty, Lordship.
No, my
On
lord,
Tuesday, Lordship. Monday
Lordship, what I am saying, my lord, the matter, Lordship will imagine a situation, my lord. Now, can they continue without a darbar?
Lordship, there are 13 members of the executive darbar. There are only 5 of them.
What I am suggesting,
implead them. Doesn't matter.
Implead them,
Lordship,
Lordship. By tomorrow, I will file an application and serve it.
The representation
Now,
has
why
been
he has
filed
then made one into a party?
on the basis of the non-sanchar of the body, Lordship. And now they already are signatories.
You already made them, doesn't matter. So it doesn't matter. They'll have the same voice only. What number 5 will make, the same noise, all these new ones will make only.
He as a party will file the application.
Anyway, we'll allow, I think, it'll be in the interest of justice. No, he prays for, Mr. Arun prays for, that he will allow to file objection. Yes. He has also submitted that they are not necessary in view of the fact that respondent number 5 in the main petition also encompasses the applicants who seek impleadment. Be that as it may, in view of the fact that in the interest of justice, the applicants are hereby impleaded as respondents. How many of them? 5.
5.
It will be added. What number? There'll be. How many were there? 6.
After 6, my lords.
After 6,
7,
yes.
8, 9, 10, 11.
7 to 11.
7 to 11. And I'll file by tomorrow.
Ready to make necessary corrections. Yes, in the court state. This case is allowed and disposed of. Next one, 218.
218, Your Lordship, is to set aside that order of allowing the petitioner to function as a Sadar.
Yes.
I have some submission, Your Lordship. If you kindly see the grounds which was there in the first complaint and the present complaint are completely different, Your Lordship.
Then we'll take on record and file objection. Here, this 218, this.
I have an interim prayer, Your Lordship. This
praying for vacating or modifying the order dated 6/12/2024 passed by this court in WC 452/2024. So issue notice. Mr. M. Nungpur is present on behalf of the writ petitioner who accepts the same and prays allowed to file objection.
Your Lordship, an interim stay to that order.
Sure, how can he be a stay on a stay?
Because he has the records, he has the money with him.
No, the last matter on Tuesday for interim stay, not to continue.
Not to allow him to continue in the meantime, because
he has a right to object. We have to examine that.
Lordship, one more submission, Lordship. I don't understand Mr. Marpana is appearing on behalf of whom, because there's no Vakalan Man record.
It's there, the appointment is there.
Lordship,
oh, he appears today only.
Yes. Appointment is there.
There's no Vakalan Man record.
Oh, last time he was not there.
No,
I was not.
Oh,
Appointment is
no.
there.
And then you record in the main case. Ms. S. Marpan is has Marpana has entered appearance on today on behalf of respondent number. They are number 1 to 4.
1 to 4.
Yes.
My lord, I have a small prayer, Your Lord. So far I am concerned, my lord. By Monday I will file an application for vacating stay.
You file it as the same summons
So
substance.
this my application itself would serve. There's
You
a lot
file
of things.
Monday.
And
We
the
take it up
learned
Tuesday
CA
for
also can file.
consideration.
Add
I'll
to
just
that.
file it by Monday.
Monday also.
So, Mr. Mopi, you're fighting your back to the wall.
I'm facing two giants. Lordship, I'm praying for Tuesday, Lordship, because Monday I have personal difficulty. Tuesday.
Raju.
Hello, Lordship.